What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. Please like this video because it's going to be good. You might as well do it right up front. Also, subscribe to the channel if you haven't done that yet. We need to get the subscribers up. I'm going to first start with the debt collectors, the debt that's being sold on the market by debt portfolio companies, old debt to debt collectors to come after people, potentially you, that are watching this video. And then I'm going to get into a back and forth that a client is going through where they're trying to get a judgment, and I'm going to talk about some of the problems that I see with it, but we'll have to see what ends up happening in the end. But I want to show you some things that maybe you've never seen before when it comes to making a debt collector prove how they came into uh, uh, possession of your debt. That it's not just about sending you a statement. It's not just about saying that they purchased the debt. I'm going to show you something that a lot of people have never seen before in this video. A lot of people never saw this before. I want to make my note here to show. This is something that a lot of people have never seen. Okay, first let's start here. We got mixed lenders, $1.6 million, charge-off date average 2000 to 2008. Obviously, it's past statute of limitations. They're selling the whole portfolio for $2,500. The average balance is $31.37. So if they get one individual that does not know their rights about debt being able to be collected, that's past the statute of limitations, and this is credit card debt, so there's a 4-year statute of limitations on there. This person could actually help the debt collector make their money back and make some money on top of it. And that's just one of the accounts, and there's 532 accounts in this portfolio. In the next package, payday loans, 1,73,529 accounts. Average balance is $2,029. They did not put a price that they're going to sell it for because payday loans usually sell for a lot more. Average charge-off date was 2017. So this is potentially not past statute of limitations in some states. All right, let's go to the next one. Another group of major credit cards. $3.3 million, 4,585 accounts, average balance $727, are selling the whole portfolio for $5,000. Average charge-off date 2008 to 2011. We got another group here, major credit cards, $2.9 million, 4,077 accounts. Average charge-off date 2011. Average balance $735. These are really low balance cards. $5,000 for the entire account or the entire portfolio. And we got another group, or that might be the same group there. That's the same one there. So let's first go with step one on what we do, and then we'll get into this court deal that client is going through. Step number one, if you get a letter demanding that you pay a debt, step number one is to look up the statute of limitations for debt in your state. You can go to my website, thecreditrepairshop.com, go to my blog, and when you type in statute of limitations, it will require you to become a free member of my website. Free, not charging you anything, free. Do that because I like to know if people are responding to what I'm doing here on YouTube. Once you find the statute of limitations, you need to go and get your credit reports. If you don't have your credit reports, I demand you, I challenge you, I tell you to go to the website that you see right here, your3scores.com. Get those credit reports, complete credit reports. That's going to show all 3 scores, going to show all 3 reports completely, and there's a couple of things that's going to be on there that you won't get in other places. Is that it's going to give you complete furniture information, and it's going to give you complete dates for charge off information. That's going to be very important for fighting a demand on a debt collection letter that you get. Now, when that account was charged off, it does not matter uh, if a debt collector has it or something. What matters is when it was charged off, because that's when the clock starts ticking. So you compare that charge off date with your state's statute of limitations. I have 4 columns on my website when you get to that page on my blog. Column number 4 deals with credit cards. The other columns deal with oral and written contracts, like if you had an auto loan where you don't charge and then you get to use the money again. Pay attention to that because it varies in different states. If it's past the legal statute of limitations to collect, go and get the letter that I have below this video, and you want to tell them get the one that says that debt validation SOL letter. You only want to use the statute of limitations letter and tell them that they're trying to collect a debt that is past the legal statute of limitations to collect. I put the verbiage in there for you. Download that letter and send it. They'll go away. If it's not past the legal statute of limitations, I want you to use my cease and desist letter, because this letter, what it actually does is it makes them make a decision on if they have all of the information to come after you for the debt. Some of the times when they buy debt, they don't get all of the information, and they have to make a determination if they're going to put their license on the line to go after you for it. Not to say that they won't, because they believe that most of you won't do anything about it anyways. So you send that letter. If they continue to come after you after you send that letter, then I want you to send letter number 3, which is the debt validation letter. You need to do a full debt validation, and then you will be moving on into the next phase if they decide to sue you. And that's where we're going to get into this one right here. LVNV funding, we've been going back and forth. They hired a debt collector in a state, and this debt collector is number one, they are new to the game. So they're like drawing this out way far. They want to get paid on this. They're drawing this out. And we number one, we did the pro se court summons response, which is where you answer the complaint. We did that for our client. And if you ever need something like that done, there's a link below this video. Only $149. It's worth doing it because at least you don't just walk in there and say, I don't know what's going on. We submitted it. Now, this has been going on for almost 7 months. We submitted it, and when they got it, they must have been in shock because they were like, nobody responds this way. We're just used to going into court and nobody does anything, and they just go in there and get a default judgment against people. Even, they can get a default judgment even if you're there, because most people lose by default because they just say, I don't know what I'm going to do about the debt. So what they did is we wrote back and forth because there were certain things that we wanted them to answer to in the debt. And they never would answer them. So we would respond, they would respond. We would respond, they would respond. We would respond, they would respond. This is months. And I just got a letter from them today where they submitted it to our client and to us, copies to us. And they're motioning for a summary judgment with a non-jury collection. So they want the judge to make a decision on this without even having people come to court and saying, hey, we've done our part. And what they did is they quoted. This is how I know that this law firm is new to this whole thing, because what they're doing is they're quoting laws or court decisions from previous court actions where people were being sued by debt collectors, and that the debt collectors ended up winning. And basically what it comes down to, what their whole thing is coming down to, is that LVNV funding has a right to collect the full amount of a debt that they came into ownership of. That's basically what they're stating. And they went and did a whole bunch of research with other court decisions that happened to go the way of debt collectors. Not, and we all know that there's been plenty that have went the way of the defendants, the debtors who owed. So they submitted this response, and I'm going to review it and see which way our client should respond to it. But there's still problems. I'm going to tell you number one problem that I have with this, and I'm going to show you with these letters here. I'm not going to disclose the customer, uh, but now they became into possession of this account, and they still refuse to disclose the complete account number. And they just, for some reason, want to just bypass that. So what they've done over these back and forth times with documents, and because of COVID, none of this is going on in a courtroom. This is just documents to them, documents to the court, documents to them, documents to the court. And what they're doing is they're just finding cases that debt collectors won, but they keep skipping over the main thing that the client asked for, which was a full debt validation, including the contract from LVNV funding showing that he had to pay them, and disclosure of the complete account number. Even on their documents that they submitted back, they still have not disclosed the complete account number. That would be like me walking down the street and saying, you owe me money, and here's the invoice, and I X out all of the numbers except for 4 numbers saying that's your account number. Like you couldn't have had any other account number with my company or another company. They cannot do that. So what I want to show you, they have their exhibits, and they went as far as to get the bill of sale, and they went and got a new, fresh copy. Not, well, this isn't even a copy. This is a fresh transcript. They even put it in color so they can try to, make it like, hey, this is more legit because it's not just a copy. This is the exact, shows their signature, even the colors of the pens in here. And it's showing that it was sold, the debt was sold. But let me tell you the problem with it. And this is actually goes back to what happened to me back in the 90s or early 2000s when I uh, kind of won against the debt collector, but I didn't know what I know now. I wouldn't have even had to pay anything. But just to give you a little bit of research on it, a little bit of history on what happened to me. And I was in the United States Army, 17, 18 years old back in 1988. And I got a credit card. The total amount that they probably allowed me to charge was $500. I'm just going to say that. But when I was in the Army, my income was only $600 per month. So I don't even think it was 500, but let's just give them 500. I mean, I don't want to embarrass myself. Uh, but $500, and then it's from what they're saying is that I did not pay the $500, and then when they finally caught up to me and tried to get a judgment by buying the old debt from the credit card company, they said that I owed $4,500, and I was like, I don't owe nobody $4,500 from a credit card that I got when I was 18 years old. They didn't give me $4,500. And so what ended up happening is I said, I'm going to court. I told my wife, I'm fighting this. And this is way before I started the credit repair shop, but it was after my wife and I had went through the 90s getting out of debt. We were 300 grand in debt, and it took us from 1994 all the way to 1999. And that's why I learned a lot about credit repair. That's why I learned a lot about debt settlement, because I had to do it on myself. I know how people feel. I know the time that it can take. I know the frustration. I know about fighting with your spouse. All of that. I've went through all of it. And if we did not make that decision at that table during Christmas that we were going to get out of debt, I would not be married today. Now we're almost 32 years married. So what I went to court, and I basically said something that I don't even know if a judge would accept now, But I said, I do not remember owing this amount. And the judge must have been a consumer friendly judge because he said, prove it to him. And they asked for a continuance for another hearing. And when I came in there, well, they had sent it to me. They mailed it to me. It was a stack that looked like this, but it was a stack. And they did it. This company, they just did it. So look, I'm going to thumb through here. You see this? These are stacks. Well, it's hard to see that way. These are stacks of credit cards that they purchased at the same time they purchased my client's credit card. They have to do it this way. This is what they don't want to show you. This is what they actually don't even want the court to know. This is why this attorney feels emboldened because he don't have to go to court with this and have the judge look through this. Even though they may have gave it to him, the judge will look at this and be like, what the hell is this? And what they do is they put your name and they redact everything. And they just put your name, and this is all of the accounts that they purchased. They don't want people to add this up. And it still redacts the complete account number. And this is the part that they do not want them to ask the question about, because you have a right to get all of the information to make sure that it's your account, to make sure not just a piece of it, not just 4 digits. What about the rest of it? Some people may be thinking right now, is that true, Steve? Will they, if I go to court and I ask for them to reveal the complete account number, will they do it? Do they have to do it? Yes, they do, or this is incomplete. You could fight just basically on that point. And basically what I did on accident when I went through mine with that attorney is I asked for that information because I said, I never had no card for $4,500. And they came and they mailed me that stack. And it had all of that on there. And I said, I don't even know if this is mine. It has my name right here, but I don't know nothing about that card. You want to know what the judge did? And I didn't know at the time that I could have asked for a dismissal. I did not know. But let me tell you what the judge did. He said, y'all go in the back room and y'all work something out on this. And you know, when I came out of there, I settled for $500. It was $4,500 and some change. And I came out of there and I just said, he started at, I think, 3,000, 2,000. I was like, I didn't owe that amount of money, period. And I came out of there and it was $5,000. And the judge said, well, Mr. Williams, you're lucky that you settled that for $500. You're lucky. I was thinking to myself, hey, I don't even think I charged $500, but I want to just get this over with and done so I can move forward. I just spent 5 years getting my credit back to where I needed it to be and getting ready to buy this new house for my family. I don't need this mess right here. $500 and it's done. Not on no public records, no nothing. It's all gone. And so I was like, just, I'll bring the $500 to you. When I took the $500 to the debt collector's office, because I said, I'm going to bring it to you. And debt collectors don't like you walking in there bringing them money. They get scared. Debt collectors get scared when people bring the money to them. I'm going to tell you about another story that happened to me also, where they got really scared. So I walked it in there and I said, it's $500. This is what we agreed on. And they also, when I went to court the first time, it was just the lowball attorney. I don't want to say lowball, like just inexperienced attorney. And when that happened, the owner of the debt collection firm, the top lawyer, showed up for the next hearing, and that's who I did the negotiation with. And when I went and took the check for $500, money order, don't never do a check, never get them access to your account. Took the money order to them. They wouldn't even accept it because they were like, there's no way he took $500 for that. I could see right here it says $4,500 and some change. There's no way. Is this just like a payment? And I said, no. And then they went and got him, and he signed it because he knew that it was past the statute of limitations. He knew that I didn't owe that amount, and he knew what I was showing you right here. He knew. He knew. Now, he have his little. He have his uh reps. You know, debt collectors calling, telemarketers calling. They don't know about all of this. They just make the calls, do what he says. They don't know about all of this, and that's what I'm teaching you in here. Now, I'm not going to say that you're going to win every case because, hold on one second. All right, I had to take some water. I'm not going to say that you're going to win every one of them. You're not going to win every one of them, but you win some, you lose some, and that's the whole game with even credit repair. You win some over time, and you might lose some, and you just keep playing the game, and you end up winning more, and you lose, and then if you keep playing the game, you end up winning the whole game. But it takes time. So they don't want you to know about this, and but this is what's going on when it comes down to these debt collectors, and they're having, in a way, they've made it a lot easier for them because they're allowing them to do all of this stuff digital. On here it has a electronic file stamp on here, and it's making it a lot easier for them to go ahead and do this stuff because they don't have to show up. As a matter of fact, I'm even seeing where debt collectors are doing uh, debt collections in different states that they're not even in because they can electronically do this and they can do a Zoom meeting for the actual court hearing. So they don't have to be in the area, they just have to be licensed to do business in the area. All right, so let's see here. What else do I have on my charts here? One other thing I want to talk about. Uh, I talk about it in my videos, and I'm sorry that I've missed it in some of the recent ones. But I got to talk about it because uh, people have to stop being so emotional when it comes to their credit. Uh, because what's happening, what I see happen with some people, not all, some people, is that they will not make a logical decision when they are under emotional stress. And what I mean by that is because they want something to happen so bad, they get so emotionally connected to it that they don't understand the logical parts that have to work to get you to the goal that you want to be at. A lot of people have trouble with that. I admit that even sometimes I have trouble with it, but I have to bring myself in. One good thing about one of the, not just one, but one of the good things that's with the way that my wife and I have grown in our relationship is that it seems like when I'm on an emotional roller coaster, she's not, and we balance each other and get back inside of the roller coaster instead of out hanging outside about to fall off. We do that for each other. Now, I understand that some of you might be single and you can't do it, but you have to think in a logical manner, but use your emotions as your energy to keep pushing, but you have to be logical on what you're dealing with. Let me give you an example of what I mean by that. I have a customer. He is under extreme emotional pressure because he has all of these credit card debts. I think it was about 90 or 80 and $90,000 in credit card debt. His business is in a jewelry business, and he went down. I mean, people bounced checks to him that was buying diamonds from him, all types of stuff. I mean, he sells to wholesalers, and I've been helping him through it. And I told him that you know if you're not going to file bankruptcy, which he has a legitimate opportunity to do that, but he said he does not want to file bankruptcy, that he wants to work his way through it with debt settlement. And I said, well, how are you doing? He said, I can't sleep. As a matter of fact, he sent me a text because I told him there was something I needed him to do yesterday. And he sent me a text. And he sent me that text. He sent me that text at 2:04 a.m. in the morning. 2:04 a.m. in the morning. And I had a talk with him and I said, you can't let this, tear up yourself and your family over this debt. That if you have to, you might want to speak with a bankruptcy attorney. He did speak with a bankruptcy attorney, and it looks the way they changed the laws in 2006 when Bush was president, George Bush, the son, and they really did make it hard for people. Like businesses can file bankruptcy and get out of debt and all type of stuff, but bankruptcy for individuals is it's like you have to walk a tightrope and tell them your what's going on, and it's very tough. And it ends up that he just can't do it. He has certain assets that he does not want to put in harm's way, and so he's gonna have to do the debt settlement. And he asked me, well, how long would it take? And I tell him I can't tell you how long it's gonna take because the first thing that has to happen before you're gonna do any debt settlement on most, I'm not gonna say all accounts, but with most credit card companies, it has to charge off. The reason why it has to charge off is because these people are beholden to investors. You can't just say, I'm going to slash this $10,000 credit card debt that this individual owes us. I have it as a good account on the books, even though they're missing payments, and I'm just going to slash it and take $5,000. They can't do that without doing a charge off. They have to do it. They have to move that account into non-performing status, and then they can make a decision on it. Most of the time, from what I've seen with most credit card companies, is that they will batch them up, just like what happened with this one. They'll batch them up and they'll sell them in groups. That this is what this represents. This represents batches that were sold in groups. And then, when the debt collector gets it, the next step would be to do a full validation, like what we're doing with this here. You're going to do a full validation when they send a demand letter, and then if it goes to where it ends up going into court, you would have to do a debt validation and you would have to answer the complete court summons. Like there's certain things that they're going to ask you on the court summons. Some of it is, like, is this your name? Do you live in this county? There's certain rules on what they have to follow to be able to take you to court. And so that has to be answered. If it's not answered, you could end up losing. Some of the times, they don't expect you to be like you're some attorney or something. You're basically representing yourself, but there's certain things that you are going to have to know how to do, or you're going to lose automatically. I would say if your best like straight line to having some type of path of victory with when you're getting sued by a third party debt collector is to ask for full debt validation, ask for the contract to show how they became the owner of the debt, like all of that stuff. That's what was in that packet, is that they put exact paper trail, electronic paper trail, exactly how they became in control of the debt. But that does not make it 100% where you have to pay them. You still have a right to go through that full validation. And because they have not revealed that full account number, my opinion, and we've helped our clients win by forcing that action, is that they did not reveal it. I believe there's a problem with the credit card companies providing that full account number. I haven't uncovered it all the way yet, but I've just always wondered why would they redact information and not make it fully disclosed when individuals are when companies, portfolio companies are buying the debt. The it's not like that account number is good anymore. So there's some reasoning behind that. So I'm going to end the video here. I know this was a long one. I appreciate your time. If you need help with your credit, please visit us at thecreditrepairshop.com. Make sure you watch the video, What Makes Us Different. If you can follow that process, we invite you to become a customer. If you can't follow that process, please choose another credit repair service. If you need your credit reports and scores, I would really appreciate it if you go to the website the number 3scores.com. If you need the statute of limitations letter, SOL letter, you need the cease and desist collection activities letter, or the full debt validation letter, those links are below this video, and you can utilize those to at least see what you can do if you have a debt collector coming after you. Again, please subscribe to the channel, post your comments and questions. I will get in there and answer them. I do not get to answer all of them all the time. I do miss some, but I try to get to all as I can, and I also answer a lot of those questions in my video. This is Stephen A. Williams, President and founder of thecreditrepairshop.com. Thank you, and until next time.